Hello, good morning, and welcome to part 2 of the lecture on constitutional amendments by the Focal Point Law Classes and Research Center. Welcome to the most anticipated part 2 of the lecture on constitutional amendments. Like I promised in the previous lecture, in this lecture we shall be covering two subtopics. The first subtopic is the case law post the Keshavananda Bharati case as developed by the Honorable Supreme Court of India. And next, number 2, we shall be looking at some of the latest constitutional amendments. We shall be discussing the following latest constitutional amendments. Number 1, we shall be discussing the introduction of GST all over India. And next, we shall be discussing the abrogation of the special status given to Jammu and Kashmir. Later, I have one bonus for you. We shall also be discussing the world-famous NJAC Judgement. Let us start off this lecture by discussing one of the most important cases which has come up before the Supreme Court since the Keshavananda Bharati case, and that is the case of Indira Nehru Gandhi. We shall only be discussing the legal aspects of this case. We shall not be getting into the whole political situation which existed in India at that particular period of time. So let us understand the background of this case. The 39th Constitutional Amendment sought to do three things. First of all, it sought to exclude the election of the Prime Minister of India and certain other officials from judicial review. That is, the election of the Prime Minister of India and certain other officials was made immune from judicial review. Number 2, the said amendment specifically voided the High Court decision which rendered the election of Indira Gandhi as Prime Minister as void. And number 3, the Supreme Court was henceforth prevented from hearing any appeal whatsoever related to election issues. So let us try to find out what happened in this case, what was under challenge and what was the decision of the Supreme Court. So clause number 4 of the 39th Constitutional Amendment was challenged as being unconstitutional insofar as it affected the power of judicial review or insofar as it affected the judicial process. And now what was the decision of the Supreme Court? Quite unsurprisingly, the Supreme Court held that clause 4 of the 39th Constitutional Amendment was unconstitutional and void. Now let us try to understand the reasoning of the Supreme Court. Why did the Supreme Court reach such a decision? In short, free and fair elections is one of the basic features of the Indian democracy, or free and fair elections constituted one of the basic structures of the Indian Constitution. It was perfectly open for the Parliament to knock out a law on which a particular judicial decision was based, but it was not open for the Parliament to specifically void a judicial decision. It violated the principles of natural justice, more specifically, audi alteram partem, that is, let the other side be heard. Naturally, the Parliament was not happy with the curtailment of its power due to the decision of the Supreme Court in the case of Indira Nehru Gandhi. The Parliament wanted to make sure that the Supreme Court could not knock out any constitutional amendment. Therefore, with that objective in mind, the 42nd Constitutional Amendment was enacted. This 42nd Constitutional Amendment did two things. First of all, Clause 4 and Clause 5 were inserted into Article 368 and the DPSPs became superior to fundamental rights. That is, any law which was enacted to give effect to the objectives mentioned in Articles 39B and 39C were made immune from judicial review. The next case which came up before the Honorable Supreme Court was the case of Minerva Mills. The Sikh Textile Undertaking Act 1974 was placed in the 9th schedule of the Constitution. An order was made for the takeover of the Minerva Mills under the said Act and also under the Industrial Development and Regulation Act 1951. This order of taking over the mill by the government was challenged through a writ petition before the Honorable Supreme Court. In this case, clause number 4 and 5 of Article 368, which were inserted by the 42nd Constitutional Amendment, were also challenged as being violative of the basic structure of the Indian Constitution. Now, let us first understand how the court dealt with this challenge. It was held by the court that Section 55 of the Constitutional Amendment Act, that is the 42nd Constitutional Amendment Act, which introduced clause number 4 and clause number 5 into Article 368, was violative of the basic structure of the Constitution. Let us try to understand the reasoning of the court. Why did the court declare those two particular clauses as being unconstitutional? Basically, there exists a separation of power between the parliament, that is the legislature, the executive, and the judiciary, that is the Honorable Supreme Court, High Court, and all other subordinate courts in India. It was the duty of the courts to pronounce upon the validity of laws when called upon to do so, and that function could not be curtailed by the parliament. This was the reasoning due to which the Supreme Court declared clause number 4 and clause number 5 of Article 368, which were inserted by the 42nd Constitutional Amendment, as violative of the basic structure of the Constitution. Now, let us try to understand how the Supreme Court dealt with the second aspect of this case, that is the relative position of DPSPs and fundamental rights in the constitutional hierarchy of the Indian Constitution. The Supreme Court declared that Section 4 of the 42nd Constitutional Amendment, which stated that any laws which were enacted to implement the objectives mentioned in Articles 39B and 39C would be immunized from judicial review, was invalid. Now let us try to understand the reasoning of the court. In the hierarchy of the Indian Constitution, the directive principles and fundamental rights occupy the same position. Previously, the position was that directive principles were considered to be inferior to fundamental rights. We have discussed that line of case law in our lecture pertaining to the topic of directive principles of state policy. So, for if any reason you are not able to recall that line of case law which declared that DPSPs and fundamental rights are on the same level in the constitutional hierarchy, I highly urge you to stop this video, go back to the video on directive principles, and then return to this video as and when you have finished revising. Minerva Mills was a very important case decided by the Honorable Apex Court, and it is important because to some extent it lays down the current position of law regarding constitutional amendments. Therefore, let us try to go a little deep into the reasoning applied by the courts to reach the decision in Minerva Mills. First of all, founders of the Constitution, that is, the founding fathers, had envisaged a controlled constitution. By the word controlled, it means that the power of the parliament to amend the constitution was not unlimited but was subject to some inherent safeguards. Next, it must be remembered that rights without remedies are meaningless. There can be no rights without remedies. If such rights exist, they are merely an adornment or a decoration, in the words of the Apex Court. Therefore, the Parliament could not take away any meaningful remedies in case of violation of fundamental rights. Let us take this opportunity to start discussing one of the most important constitutional amendments of our time, and that is the introduction of the GST, or the Goods and Services Tax, by the central government. Now, please note that we shall be discussing this topic only from the perspective of constitutional amendments. We shall not be touching the aspects of this subject which are related to taxation or which are related to company law. So, the whole structure of the GST was introduced by the introduction of Articles 246A, Article 271A and Article 269A into the Indian Constitution. It was introduced by the then Finance Minister of India, the Honorable Arun Jaitley. Now, there were a few objectives which were supposed to be accomplished by introduction of the Goods and Services Tax. They were ease of collection of taxes, increase in the collection of taxes, and convenience for everyone, for the central government, for state governments, for manufacturers, for private individuals, or the ultimate consumers. It is time to critically analyze the whole structure of the goods and services taxes from the perspective of constitutional amendments. Therefore, the first thing that I want you to remember is that the tax structure which existed in India pertaining to levy and collection of indirect taxes by both the central government and the state governments was completely overhauled by the introduction of the GST. The GST Council was established to recommend the rate and the amount of taxes to be collected, and also to determine the manner of distribution of those taxes between the central and the state governments. Now, legally speaking, the recommendations of the GST Council are not binding on all of the states. However, if a state is aggrieved by any of the resolution or recommendations of the GST Council, they have no real remedy. They have to approach the GST Council itself. Therefore, they have to seek a remedy before the very body against whose decision they are aggrieved. Therefore, they have no real remedy if the states are aggrieved by any of the decisions or recommendations of the GST Council. Moving on, please remember that in my personal opinion, the whole structure of the Goods and Services Tax is biased in favor of the central government. Now, why do I say that? First of all, the main reason for the bias in favor of the central government is that the central government has veto power in the GST Council. Even if all the states put forth a recommendation, the central government can use its veto power to defeat that recommendation. Therefore, in my personal opinion, the whole structure of the Goods and Services Tax as it exists right now is violative of the basic structure, and to be precise, the distribution of power between the central government and the state government. Before the introduction of the GST, the power of the central and the state governments to levy indirect taxes was distributed on an equitable basis. The introduction of the GST has seen the usurpation of some of this power by the central government, and as a result, in the field of indirect taxes, central government has become more powerful than the state's government, which was not what was envisaged by the framers of the Constitution. They had envisaged an equitable distribution of power of taxation, to be precise, indirect taxation between the central government and the state government. Now let us start discussing the important topic of the abrogation of the special status given to the state of Jammu and Kashmir. Now, this is a very controversial topic. Therefore, we shall not be discussing the historical and the political aspects of this topic. We shall be looking at this topic from a purely legal or constitutional perspective. So, the special status accorded to the state of Jammu and Kashmir was abrogated or cancelled or nullified by the Jammu and Kashmir Reorganization Act 2019. Now, This decision taken by the central government to abrogate Article 370 and divide the state of Jammu and Kashmir into two union territories was challenged before the Honorable Supreme Court through several writ petitions. One of the grounds of the challenge was that, among other things, this Reorganization Act of 2019 destroyed the basic structure of the Constitution. One of the grounds of challenge before the Honorable Supreme Court was that by passing the Jammu and Kashmir Reorganization Act 2019, the Parliament had circumvented the procedure contemplated for amendment of the Constitution under Article 368. We shall limit our discussion to this head or to this ground of challenge only, because this is a video related or pertaining to constitutional amendments. Article 370 of the Indian Constitution was placed in Part 21 of the Constitution. The heading of Part 21 is Provisions of a Temporary or Transitional Nature or Special Provisions. Now, please try to recall the status of temporary provisions of the Constitution. What is the procedure contemplated for amendment of temporary provisions? If you recall, the procedure is simple legislative procedure. The procedure which is used for passing any ordinary laws or bills in the Parliament is to be used for amending temporary provisions of the Constitution. Therefore, in my personal opinion, the great debate which surrounded the abrogation of Article 370 was totally unnecessary. Clearly, Article 370 was a temporary provision because it had been placed in the part of the Constitution which was specifically named Temporary, Transitional and Special Provisions. Therefore, what was a temporary provision had achieved the status of an almost entrenched provision simply because it was undisturbed by the ruling party at the center for decades together. Now, let us try to understand the decision of the Supreme Court in this case, and let us also try to figure out the reasoning which was applied by the Honorable Supreme Court in reaching this decision. So, first of all, it was held by the Honorable Apex Court that there were a variety of factors which indicated that Article 370 was not an entrenched provision. On the other hand, it was in reality a temporary provision. Number two, it was held that the power of the President to abrogate Article 370, which was found in Article 370 itself, to be precise, in Article 370 subclause 3, had not lapsed or it had not come to an end simply because the Constituent Assembly of Jammu and Kashmir had been revised, and therefore, as a result, the Jammu and Kashmir Reorganization Act 2019 was intra-virus of the Parliament, that is, it was perfectly within the competence of the Parliament to abrogate the special status accorded to Jammu and Kashmir through Article 370. The decision which was rendered by the Supreme Court in this case is not as easy as it sounds. So, let us try to explore the relationship between Article 370 and Article 368 according to the reasoning given by the Supreme Court in this case. So, first of all, I want you to remember that according to Constitutional Order number 48, any constitutional amendment does not become automatically applicable in the case of Jammu and Kashmir. It only becomes applicable if it is made applicable by the order specifically passed by the President under Article 370 subclause 1. And next, I want you to remember that the procedure contemplated under Article 368 was not used for the abrogation of the special status given to the state of Jammu and Kashmir. Why was the procedure contemplated under Article 368 not used? What was the reason? The only reason why that procedure was not used is because There is a provision for the abrogation of special status given to Jammu and Kashmir within Article 370 itself. Therefore, there was no need to resort to the procedure contemplated under Article 368. Now, let us start discussing the NJAC judgment. Like I said previously, this judgment is also related to the topic of the powers and functions of the Supreme Court. When we discuss the powers and functions of the Supreme Court, we shall be discussing this case once more. For now, we are going to be discussing this case from the perspective of Article 368. So let us find out what this case was all about. First of all, one of the agendas of the NDA alliance before the 2014 elections was introduction of the National Judicial Appointments Commission. So, when the NDA government came to power in 2014, they immediately introduced the 99th Constitutional Amendment. By the virtue of the 99th Constitutional Amendments, Articles 124A and 124C were introduced into the Constitution, along with several changes being made to other articles pertaining to the power of the Supreme Court to appoint judges to the Supreme Court and the High Court. And finally, this was followed by the enactment of the National Judicial Appointments Commission 2014. The 99th Constitutional Amendment and the National Judicial Appointment Commission Act 2040 were challenged before the Honorable Supreme Court through several writ petitions. The Honorable Apex Court dealt with all of these petitions in a single judgment rendered in the case of Supreme Court Advocates on Record Association and another and the Union of India. The decision was rendered in the year 2015. Now let us understand what was the decision of the court. What did the Supreme Court decide? So first of all, the Supreme Court held that the primacy of the opinion accorded to the Chief Justice of India, which is formed in consultation with his brother judges, is one of the basic features or one of the basic structures of the Constitution. Let us try to understand the argument which was put forth on behalf of the respondent, that is the Union of India. So basically, on behalf of the central government, it was argued that the National Judicial Appointments Commission protected the primacy of opinion accorded to the Chief Justice of India, which was formed in consultation with his brother judges. However, the Supreme Court did not accept this argument, and it was held that the scheme under the National Judicial Appointments Commission did not contain adequate safeguards in order to protect the primacy which was supposed to be accorded to the opinion of the Chief Justice of India. Therefore, as a result, the Supreme Court struck down entire Articles 124A and 124C as violative of the basic structure of the Indian Constitution, and naturally, as an obvious corollary, since the National Judicial Appointments Commission Act 2014 emanated or originated from Articles 124A and 124C, it was also struck down as being ultra vires of the Parliament.
Thank you for watching. If you have been using our videos for revision before your exams, consider liking this video and subscribing to our channel. We shall be back with a new lecture series on the Code of Civil Procedure very soon. Thank you once again.